Well, on the eve of the first significant pretrial hearing in the case of United States of America versus Donald J. Trump, defendant Trump and his criminal defense lawyers were crushed in another court in another state, where Donald Trump is not yet a criminal defendant. As we were just saying, the Georgia Supreme Court emphatically and enthusiastically and very, very quickly dismissed Donald Trump's attempt to block further proceedings in the criminal investigation against him for trying to overturn the presidential election results in Georgia. Former Georgia District Attorney Gwen Keyes Fleming will join us later in the hour to consider the content and the very high speed of the Georgia Supreme Court's ruling, which did not allow Donald Trump's motion to survive one full business day on the Georgia Supreme Court docket. So Donald Trump and his criminal defense lawyers in Georgia suffered a total wipeout today, but his criminal defense lawyers in Florida have higher hopes in federal court tomorrow because Donald Trump appointed the judge who is presiding over the federal criminal prosecution of Donald Trump. For the first time in history, a federal judge is presiding over the criminal case of the person who appointed the federal judge. We should never get used to how outrageous this is. Judge Aileen Mercedes Cannon should recuse herself from the case because of the appearance of a conflict of interest in a federal judge handling the case of the person who appointed the federal judge. This particular conflict of interest has never come up in the history of the federal judiciary because no president or former president has ever become a criminal defendant. Judge Cannon showed herself to be hugely prejudiced in favor of Donald Trump when she handled an earlier stage of the case and was rebuked for her unconstitutional rulings by the Federal Court of Appeals. So the suspense is mounting as 2 p.m. tomorrow approaches for that hearing on the question of whether Judge Cannon learned her lesson by being rebuked twice by the Federal Appeals Court for making completely baseless rulings in Donald Trump's favor, or does Judge Cannon still not care about the law or criminal legal procedure or the Constitution or being rebuked by the Federal Court of Appeals? Tomorrow's session will not necessarily answer all of those questions, but it could give us clues. Donald Trump's lawyers are asking for an unlimited delay in the case. Special Prosecutor Jack Smith and his team of prosecutors are asking for a trial date of December 11th. And today, Jack Smith filed a new motion in the case asking the judge to issue a protective order pertaining to classified information in the case. Jack Smith submitted to the judge a draft of the protective order that the prosecutors would like the judge to issue, and that order would say the defense may not disclose or cause to be disclosed in connection with this case any information known or reasonably believed to be classified information. Some of the proposed protective order is boilerplate that would always appear in cases like this, but might, for the first time in history, become a point of contention in this case, including the proposed definition of classified information. Classified information shall include any document, recording, or information that has been classified by any executive branch agency in the interests of national security. It is possible that Donald Trump's criminal defense lawyers will argue with that definition, suggesting that even though something has been classified, it might not still be classified because Donald Trump may have, at some point, personally declassified the document, or at least think he did. No other criminal defendant in a classified documents case could ever have made such an argument. The proposed order also says all classified documents or material and the information contained therein shall remain classified unless the documents or material bear a clear indication that they have been declassified by the agency or department that is the originating agency of the document, material, or information contained therein. There will be no debate on a point like that. There would be no debate on a point like that in any other criminal case involving classified documents. But with the Trump criminal defense lawyers tomorrow. No one has any idea what they might argue. And of course, the proposed order says the defense and the defendants shall not disclose classified information to any person. That is clearly aimed at Donald Trump, who may have been showing a classified document to people during an audio recorded conversation in which he describes classified information and in which it sounds as if he is holding paper in his hands. Jack Smith's proposed order on classified information also includes a provision in anticipation of any possible leaks in the news media about classified information. It says, if classified information enters the public domain, the defense is precluded from making private or public statements where the statements would reveal personal knowledge from non-public sources regarding the classified status of the information. So, if classified information appears in, say, exclusive reporting in the Washington Post, Donald Trump is essentially not allowed to comment on that, according to this proposed order. This order suggests a version of the world which we cannot imagine, a world in which Donald Trump is controlled in what he can say publicly. Any other defendant would live in fear of violating an order like this. Donald Trump knows even if the judge issues this order, it would be up to the judge to enforce this order, and Judge Cannon is the friendliest judge to Donald Trump that we have ever seen anywhere in the American judiciary. Another boilerplate line in the proposed order sounds absurd in the world of Donald Trump. Quote, the defendants have a continuing contractual obligation to the government not to disclose to any unauthorized person classified information known to them or in their possession. Donald Trump does not know how to live like that. That's why he's a criminal defendant in this case. Speaking of not knowing how to live like that, there's this provision in the proposed order. The defense shall not discuss classified information over any standard commercial telephone instrument or office intercommunication system, including but not limited to the internet, electronic mail, or in the presence of any person who has not been granted access to classified information by the court. We know Donald Trump has had many discussions over standard cell phones while president. And the most ironic line of boilerplate in the proposed order is on page 14. Quote, mishandling of classified information may constitute violations of federal criminal law. That is, of course, exactly why Donald Trump is a criminal defendant in this case. And the proposed order imposes very strict limitations on the criminal defense lawyers in the case, saying that the defense lawyers, quote, shall not disclose classified information to the defendants other than materials marked provided to Donald J. Trump in United States versus Trump or provided to Waltine Nauta in United States versus Trump. The defense lawyers can be severely sanctioned for violating whatever order Judge Cannon decides to issue. The final item in Jack Smith's proposed order pertaining to classified material is going to be the perfect final scene in the HBO series about this case. It says, the notes, summaries, and other documents prepared by the defense that do or may contain classified information shall remain at all times in the custody of the Classified Information Security Officer for the duration of the case. At the conclusion of this case, including any appeals or ancillary proceedings thereto, all such notes, summaries, and other documents are to be destroyed by the Classified Information Security Officer in the presence of counsel for the defendants if they choose to be present. You can imagine the credits rolling over the flames of the burning notes and other documents created by the defense lawyers. In the accompanying motion asking for this protective order, Jack Smith gave Judge Cannon a diary of delay thus far by the Trump criminal defense lawyers beginning last Wednesday. On July 12, 2023, the government sent to counsel for the defendants the proposed protective order. On July 14, 2023, counsel for the defendants informed the government that they intend to object to certain provisions of the proposed protective order, but did not specify any such provisions. Because the entry of a protective order is necessary to provide any classified discovery to the defendants, the government respectfully requests that the court require the defendants to file on an expedited schedule any objections to the proposed protective order. In an effort to narrow any disputes, the government asked to have a call on July 14th with counsel for the defendants in order to see if it was possible to address the defendants' concerns. Defense counsel informed the government that they were not available that day, but could find a time for a call the following week. Government counsel responded that the government did not want to delay filing this motion because a protective order needed to be entered prior to the provision of classified discovery. The government counsel would be available for a call over the weekend, and that it would be helpful for defense counsel to identify the provisions they found objectionable. Government counsel has not heard further from defense counsel since sending that email on July 14, but is filing this motion now to avoid further delay. In a footnote, Jack Smith noted another delay of as much as 2 months already built in to the pretrial process. Quote, "We expect that defense counsel who currently are approved for interim security clearances will receive final clearances within 45 to 60 days and will promptly receive additional read-ins upon receiving such clearances." So the Trump criminal defense lawyers are 2 months away from even being allowed to see all of the classified evidence in this case.